Hi, we are here now. I am Attorney Britannico. I'm here with Erica, who has some questions about inheritance and inheritance law. So I'm happy to see you, Erica.
Hi, Attorney Franco. I'm very glad to be here. And I do have some questions, and I'm very interested in knowing about laws regarding inheritance. Um, first off, I would like to ask how have you been in the industry of law, and how many years have you been in the law? And a little bit of story about how you want to help people through this channel.
Oh, I've been practicing law for about 14 years. I went, I graduated from the University of the Philippines, and my practice, a lot of it has been in litigation and family law, uh, corporate and labor concerns as well. But is for inheritance, for the question of inheritance, the I get asked a lot of questions, and they tend to be similar questions because when somebody in a family passes away, people don't know what to do. They don't know what how to start, and a lot of times they haven't prepared for the passing away of a family member, and they need to understand what they need to put together in order to settle an estate.
Right. Wow, that's very helpful. And we're very thankful that you are here to help a lot of us, especially me, to understand some things about this topic. So while we're at it, I do want to ask that when these things happen, especially we have the pandemic, a lot of people have lost so many loved ones. And especially if it's a very small family, including one child, what happens what typically happens when the parents pass, and how do the only child, for example, get to know about their inheritance from their parents, especially if they have not left a will, or any written document for the child.
It's not unusual that there's no will. It's a lot of the time people are unprepared. It's not something that the people want to think about or plan for. So if it happens that a parent or the parents pass away and the child is left behind, the child has to find out what the legal picture is. The first question really is who are the heirs, and related to that, what are the properties that are to be inherited? What are the obligations of the heir? And how is the estate going to be settled? The question on who is the heir, if there is one child, both parents having passed away, is that usually it's only the child. Under Philippine law, if there's no will, the civil code makes provisions for who is actually going to be the heir. And the general rule is the descendants exclude the ascendants, and in, the heirs in the direct line exclude those in the collateral relatives. In simpler English, what that means is that the child will exclude the parents of the parents. So the grandparents will not be heirs if there is a child. And the child as well will exclude the uncles and the aunts. The siblings of the parents will not be inheritors as well. So all the properties of the parents, the married parents, go to the single child. And the single child's job now is to settle the estate, first by gathering information about what the estate actually includes, and then settling obligations with the government, with creditors, and then he can adjudicate the property, the estate, to himself.
Okay. Well, that's very clear. That's very nice to understand. And I do want to ask on that part a little bit of a follow up. So this child, if it's the only child, should that person be the a legitimate child. So what happens, because we have, there are many cases where families have been very complicated and there are other issues. So what does the law says about legitimacy, or how does it happen if what does the law says for these cases?
Well, okay. For the legitimate child, the child born of a marriage, he will be the sole heir. He will be the heir of his parents. The illegitimate child can inherit as well, will certainly will inherit as well. He is also a compulsory heir. The compulsory heirs are the ones whom the law reserves shares for, regardless of whether there is a will or there is no will. They cannot be excluded from the inheritance unless a will was made to explicitly exclude them. So in our situation, we there was no will. So well, the child, whether legitimate or illegitimate, he will inherit. He's entitled to an inheritance from the parents. The This goes as well for adopted children. An adopted child is legally a child of the parents. So for in all respects. So if his parents or her parents were to pass away and they left no will, all the properties of the parents would go to the adopted child in just the same case as a biological child.
Attorney, I do want to know, of course, it's already been a bit of a burden for the only child to have his or her parents pass. And aside from that, he's now or she's now responsible for all the things that they will inherit. So how does one child, how does this child um, have to deal with this, or how does she or he have, what does she have to do in order to manage all these inheritance from the parents?
Well, the law says that the single child, the sole child who is the only heir, can make a an adjudication to himself or to herself of the entire property. This is a formal document where the child states that the parent or the parents died without a will and that there are no longer any debts which are payable from the parents to any creditors. So I guess that's one thing is to check on first, are there outstanding obligations that the parents have needed to have settled? Those will need to be paid. And then the child in this deed of sole adjudication also needs to identify the properties that form part of the parent's estate. So the estate is simply what the parents leave behind for their heirs. And the estate needs to be its scope needs to be identified. You need to find out exactly what's included. Sometimes it's fairly clear. You know what your parents owned. You're aware of what the house or the land or the bank account is, but sometimes it's not so easy. Sometimes it takes some investigation. You have to go find the parents' bank records. You need to go find their documents to identify what properties they were, what properties they were that were owned by the parents, and then you need to tally all of that. So you find out what the assets are essentially. What are the houses or the house, the land that they might own. It might be sometimes there's property in Metro Manila or the city, and there's also property in the provinces, and you have to do some detective work, or at least ask your relatives, ask the local people in the areas to identify these properties. And then after that, you need to see that the documents on these papers exist. Are they there? You need to go find them. And you need to find out if there are any obligations on these properties. So a lot of what you need to do is you check with, well, after you find the paperwork, you perhaps you find them in a safe in your parents' uh, in possessions, in a drawer, in a filing cabinet. Sometimes it's not that organized, unfortunately. So you need to identify all of that. Then you have to track down what the uh, what the current titles are. A lot of the time, these documents are not up to date. So you need to go back to the local government where the titles are recorded, or at least to the Register of Deeds, the LRA, the Land Registration Authority, and find out what the current state of these are. Are they actually still owned by the parents? Have they been transferred? If they have, if they're still owned by the parents, are there outstanding obligations on them? So there's a lot of paperwork to be looked into, both at the national government office level and the local government office level.
Attorney, what if the only child is still very young? So, will they be needing, if they will be needing some help in managing this, how do we address it?
If the only child is still very young, that's a good question. Typically, this sort of thing needs to be addressed by an adult. So if
Right.
the child's young, a representative or a legal guardian will need to do these things. If the parents passed away, then perhaps it's the grandparents who will step in on behalf of the child or the nearest of kin. Or sometimes it might go as far as having needing a court appointed guardian to look after the best interests of the child and undertake the settlement of the estate. So there, the law provides for a sequence of the nearest kin or the nearest relatives until the point where if none of those are able to step in, the court can appoint someone to act on behalf of the child.
Okay, I understood. So for these papers to be handled, the child or the guardian who will be in charge of it, they will need to have the papers or documentation. But a lot of times, especially here in our country, there are so many instances wherein there's no documentation or there's no original document or ownership. So what do they have to do if they know that their parents own something but they don't know what to do, or they couldn't find the documentation for it? So is there anything that they should do about it?
Okay. The properties in the Philippines, land in particular, land and real estate, they are recorded. The ownership records are registered in the recorded in the registry of deeds. There's a local registry of deeds for every local government, municipality or city, and of course there's the national office. The owners of a property are supposed to have the owner's copy of the title to a property. Sometimes this title might be lost. Sometimes this title, not just the owner's copy, but even the copy of the registry of deeds, if it's been burned or it's been destroyed in the course of some catastrophe, there are different remedies that you need to undertake. If, for example, there's a lost title, you need to apply in court for the reissuance of a new title. So, for example, you know that your parents owned a house in a certain province, and the municipality in the province still has the registered title in its records, but the owner's copy is missing. To retreat to be reissued a new owner's copy, you need to file a case in court for the reissuance of a new title. So it's a bit complicated in that there are steps that you really need to do in order to get these documents back. So it would be really helpful for the parents who are holding these documents to make sure at least that the children know where to find them. Because if the title is lost, it's burdensome. It adds a lot to the process to go to court and ask the court to order the registry of deeds to issue you a new title so that you have a new owner's copy. It takes a court order. So a lot of this, even though people don't prepare for death for various reasons, it's really helpful that they should do so, so that the heirs, should something happen, won't be at a loss, doubly at a loss, for what to do. They having lost a parent, then having needing to go through the trouble of finding documents which the parents might not have told them where to find.
Right. So for every asset that the heir will inherit, the first goal is for them to find documentation, whatever it is. Where is it? Whether it is a land or even stocks. Should there be documentation for everything, attorney, for all of that?
Generally, yes. Some properties, of course, they don't have title. Some properties, like the personal properties of the mother, perhaps she has personal items. These are not recorded in the Philippine registry system. But land, buildings, condominiums, shares of stock, these are all recorded in different government offices. The Registry of Deeds, the Securities and Exchange Commission, the titles to these properties, they can, in concept, they can be transferred to other people. The ownership can be transferred to other people, but you can't actually effect the transfer of title by the Registry of Deeds saying that the property is no longer owned by the parent. It's now recorded in the name of the child, unless you're able to show the original document that the showing from the parent, and then showing the reason why it's transferred from one owner to the other. So in the case of death, you need to show the titles. In the case of for shares of stock, you need to show proof that there's a valid transfer of the shares of stock. And the other side of it is that before you can go to the registry of deeds to effect the transfers, the government will ask if the transfer taxes on these titles have been paid. So you're not going to be allowed to record a transfer of ownership at the Registry of Deeds, for example, unless you show proof that you've paid the BIR, the Bureau of Internal Revenue, you've paid them the appropriate taxes. There's transfer taxes involved. The process of changing ownership, if in the case somebody died, is that it involves showing the proof of ownership and showing the proof that you've settled the estate. So the Deed of Sole Adjudication that we mentioned. And along with other supporting documents, you bring this to the Bureau of Internal Revenue, and then the BIR is going to assess taxes. How much should be paid to the government for the transfer from the deceased to the heir. So this is going to be based on the value of the estate, the value of the properties. And it's only after you have made this payment that the BIR is going to issue a certificate, an electronic certificate authorizing registration, which you can then present to the Registry of Deeds to show them that the taxes on the estate have been paid, and therefore the assets, the house and lot, or the land in the name of your parents can now be transferred to the child.
Okay, attorney, so we really need the title and with the parents' name on it. So any other proof? Of course, there are also needed, other ownership documents are also needed. But what if they only have tax declaration or any other proof aside from the title? Will that be okay?
Well, the tax declaration is a supporting document for purposes of transferring. That's one of the supporting documents you need to submit to the BIR. For one of the reasons is the BIR will not authorize the registration, the transfer, unless you've paid the annual real property taxes due on properties, because there's taxes for all sorts of things. There's a real property tax which is payable to the local governments every year, and you need to keep those up to date. And if those are not up to date when the parents pass away, the heir has to pay the arrears before the BIR will allow you to also complete the other requirements, other payments needed to get the estate settled. So apart from the 6%, and it's been made a 6% estate tax, you also need to pay you have to make sure that the real property taxes, the annual taxes due on real estate are up to date. So those are required along with the title. If if you don't have a title, you won't be able to effect a transfer at the registry of deeds, because the registry of deeds is built around the registration of property in the Philippines. So there's effectively nothing for them to transfer title to. You have to What you can do is you can begin the process of registering the property in the name, registering the property, actually putting a title to it in for the first time, so that it can therefore now be part of this system of recording at the registry of deeds. Otherwise, you cannot complete the process for registration, because it hasn't been registered yet, and you will have to be the first one to do that.
Attorney, what if I know, for example, I'm the only child and I know that this property is owned by my parents. However, the title is, in someone else's name or still in my grandparents' name who have also maybe passed, or what can I do about it? But, about this issue.
And that's not unusual. A lot of the time, the what happens is the family has always owned the property as far back as people remember.
Right.
There's a property, perhaps it's farmland, perhaps it's a house, it's the ancestral home, and it's been in the name of the grandparent. The grandparent died, and then the children of that grandparent, the parents' generation now, they never settle the estate of the grandfather. They just decide among themselves that one child will continue to live in this property, and then the rest, they don't mind. They just go on with their lives, and then when it's time for that child and he passes away, and then the third generation, the grandchildren, are left to figure out what to do now with the property. At that point, the children might be scattered all over the world, or and they need to figure out how is this title going to be transferred, what to do with it. The short answer is you need to settle the estates of those who passed previously. So you need to settle the grandfather's estate also, and the estate of the parent. And all the living heirs now need to sign off on the settlement. So what the situation is that this is not going to be a sole adjudication. This is going to be a matter between cousins and uncles and aunts. Essentially, all the heirs of the grandfather need to sign off on an agreement on how the property is to be divided. The other consideration, the other major aspect of that is that you need to pay the estate taxes for both generations, the grandfather and the parents' generation. And estate tax is something which needs to be paid generally within 6 months or a year, depending on when the what period or when the person died. Within 6 months or a year from the death of the the owner. So if the grandfather died, the estate tax should have been paid within 6 months of his death. And if there was failure to do that, it will accrue interest. It will accrue a surcharge and penalties. These are sizable because they go on year after year. So it accumulates and it accumulates until it's not unusual that the value of the amount of the interest or the penalties might in fact be much more already than the value of the estate. And then you add to that now the after the parent dies, that will also be answerable for an estate tax. Now, it used to be that the estate tax was considerably more than 6% for high value properties. And so there became the problem that the families are locked out of being able to do anything with the properties. Because yes, they'll continue to have possession of it, but they're not able to go through the process of settling the estate because they look at the amounts involved and it's not mathematically it doesn't make sense to pay the this amount and then pay more than what the value of the apparent value of the property is. Fortunately, the government has, in the last couple of years, issued opened an amnesty on the estate taxes so that the surcharges, the penalties, the accrued interest for, let's say, the last 30 years or so are waived by the government. If you just settle the estates and then you will just be taxed at a flat rate of 6%. So the grandfather's estate will be taxed only at the 6% and the 30, 40 years of interest are waived because the government sees this as a win-win. One, these properties are freed from being locked away from the economy. Essentially, they can be freed now if the families will settle it. The families will be free to do something with the property. They become free to sell it because they can now have it titled, and then the titles can be transferred, and the government will have the benefit of the economic activity and also the benefit of the families actually paying the estate taxes, even at a reduced amount. So the estate tax amnesty has been extended because of the pandemic. It was due to expire last year, but the government extended it until 2023. So it's good news for families now if they want to settle estates from the grandparent, even the great grandfather, or the parent who died 10, 20 years ago and the taxes were never paid. They can pay it and no longer be subject to the estate tax penalties and surcharges, and just pay the flat rate of 6%, reduced even from the previous rate that was enforced at the time of the death of the grandfather.
Wow, that's really great news, attorney, for the children who want to handle the estates of their parents and even their grandparents. Because a lot of Filipino families have very big families and they share all of these properties. So thank you so much for sharing on that part.